Good morning, Your Honors, and welcome to Arizona. My name is Jim Jellison, and I represent the City of Buckeye police officer, in this case, David Grossman. I'd request to reserve 3 minutes for rebuttal.
What's your time?
I'd like to start off by actually looking at some of the law that's absolutely clearly established because it comes from the U.S. Supreme Court and because it comes from the Ninth Circuit Court of Appeals. So when we talk about what officers are expected to do in terms of investigating crimes, we can look to Adams versus Williams, 1972 U.S. Supreme Court, that tells us that the Fourth Amendment does not require a policeman who lacks the precise level of information necessary for probable cause to arrest to simply shrug his shoulders and allow a crime to occur or a criminal to escape. On the contrary, Terry recognizes that it may be the essence of good police work to adopt an immediate response, a brief stop of a suspicious individual in order to determine his identity or to maintain the status quo momentarily.
Counsel, Terry talks about reasonable suspicion of articulable criminal activity afoot. This is also at the pleading stage. As alleged in the complaint, what paragraph has anything from which a reasonably objective police officer could find a justification for either a Terry stop, the application of physical force, or an arrest? Where is anywhere in the complaint give us anything that would justify any Fourth Amendment intrusion on the 14-year-old boy's liberty?
And just looking at reasonable suspicion, Your Honor, I go to the complaint. In our record, it's ER 86 and 87, where the plaintiff alleges that Officer Grossman is a qualified drug recognition expert who mistook.
Actually, it doesn't allege that. It says that the police department considers him a drug recognition expert. It doesn't say he was a drug recognition expert.
Okay. Fair enough, Your Honor. What it does state is that he's considered by his agency to be a drug recognition expert, and that he mistook CL's behaviors as illegal drug use.
Well, I mean,
what behaviors?
Well, the behaviors that are described in the complaint for somebody who Officer Grossman at the time didn't know, but as the complaint alleges, suffers from autism.
Oh, but the complaint says there's a 14-year-old boy in a public park during daylight hours playing with a string. I mean, repetitive motions with a string. That's all the complaint says. Maybe it's not true. Maybe there are other things that Officer Grossman saw that aren't in the complaint. But what in the complaint would allow an intrusion on a 14-year-old boy's, or for that matter, anyone's Fourth Amendment liberty interest to allow for a seizure?
And I think the answer is that what the complaint tells us is that CL was exhibiting the signs of autism, which includes abnormal, repetitive behaviors. It's one of the first paragraphs that exist in the complaint, might even be paragraph 2, and that Officer Grossman, considered by his agency as a drug recognition expert, mistook that behavior for illegal drug use.
Now, that's where I start to have a problem, because being considered a drug recognition expert doesn't mean, okay, I get to decide what's suspicious. We still need to know what objective facts constituted reasonable suspicion. And a 14-year-old boy standing in a park doing repetitive motions doesn't strike me as the basis for reasonable suspicion. And certainly not for what unfolded after that, because the complaint here isn't really about the stop. The complaint is about the physical force applied after that. And I'm still stuck at the first stage. I'm not sure there was reasonable suspicion for a stop, but I sure don't see anything objective that justifies going beyond that. So what justifies the officer's conduct?
And Your Honor, I might agree with you until we get to the part that the plaintiff alleges, and that is that Grossman did in fact mistake the behaviors that he's seeing for drug use. I grant you the complaint does not give the details, beyond that, but it doesn't plausibly allege that this was an unreasonable mistake.
I'm sorry, counsel. If there were a complaint that says Mark Bennett is walking in a park and playing with a string, and a police officer looked at him and thought that that was a sign of drug use and effected a Fourth Amendment stop, even if and that's all the complaint alleged, I just don't see how that would allow for the application of force or an interference with a person's liberty interest, absent more in the complaint. I mean, it may be that it's summary judgment. Officer Grossman will be able to do an affidavit that establishes why he had reasonable suspicion, but there's none of that in the complaint. It's a boy playing with a piece of string that somebody basically stops when the boy doesn't want to comply, exercises force, and then after the person's caregiver says it's just autism, applies even more force. But getting to the start, there has to be something alleged in the complaint which would allow an objectively reasonable police officer to interfere with his Fourth Amendment rights, and I just don't see what paragraph in the complaint that's in.
Well, it's the responsibility of the plaintiff to state a plausible claim and to put the facts in or not put the facts in. And the reality of this complaint is it does allege that this officer believed that he was looking at drug use and that this officer...
That's not the question, because anybody who makes a stop may believe, but that doesn't guarantee there are objective facts that support a finding of reasonable suspicion. And remain stumped as to what facts support reasonable suspicion, and beyond that, what facts justify the application of force.
Well, is there any clearly established law, Your Honor, that prevents a police officer when they see a teenager engaged in repetitive behavior that's abnormal, that being considered a drug recognition expert, they conclude, or I'll use the language of the complaint, mistake it for being drug use,
yes,
and that they can't...
Counsel, there is clearly established law. The clearly established law is that you need reasonable, articulable suspicion of criminal activity afoot to effect a Terry stop. And as alleged in the complaint, there was a boy playing with a piece of string.
I think the complaint alleges more than that, Your Honor.
Where?
Okay, I think the complaint alleges what the behavior is, not just playing with a string, but repetitive, abnormal behavior by this person that was enough to cause this officer to mistake it for drug use.
So let's stop right there, because the question is, what supports that conclusion?
Well,
playing with a string, stimming as it's described in the complaint, is there anything you can point to that would support the proposition that that conduct in the park in the daytime by a 14-year-old boy or anybody, it could be Judge Bennett, a well-known stimmer, how does that constitute reasonable suspicion?
I haven't seen a stimming yet, but again, I know that I'm confined to what I read in the complaint, and I know that this court is confined to what's in the complaint. But what is in the complaint is that this officer, for whatever reason, believed that he was looking at criminal behavior. It does not plausibly plead anywhere that mistake over the difference between drug use and autism was unreasonable in any way. There's no allegation in there that takes this from the sheer possibility that what he observed wasn't enough to the probability or plausibility that's required not only to get past Ashcraft versus Iqbal, but to get past Keats versus Coyle, which requires a plausible claim that deprives this person of qualified immunity. And Your Honors, what you're saying is the plaintiff didn't include enough, and what I'm saying is, yeah, there's more that the plaintiff could have included, but they included enough so that qualified immunity isn't lost.
You chose to make your motion at the pleading stage. And it's a plausible complaint for someone to allege, I was walking in the park doing nothing, and a self-recognized or an actual drug recognition expert stopped me, detained me, assaulted me and effected an arrest. Now, maybe the facts don't bear that out, but that states a plausible Fourth Amendment claim saying I was doing nothing to justify an interference with my liberty, no facts at all. In this case, it adds playing with a string, but that states a Fourth Amendment claim, and it states a plausible one. It may not prove to be true, but I would like to see you point me to a paragraph in this complaint where there is any allegation of anything that would allow reasonable suspicion or probable cause.
And Your Honor, the only place I can go back is to where I've been back before, and that is where we've got a description of repetitive behavior, we've got a description of an officer who's considered a drug recognition expert, and we've got an allegation that he mistook what he was observing for drug use and proceeded to investigate, to ask what's going on here.
You've given us your answer there. But the stop isn't really the problem. The stop is the application of physical force. And what would you point to that would, based on the allegations of the complaint, support the application of physical force and the detention that may or may not have constituted an arrest, but surely constituted detention that continued over a period of time? So what facts would you single out from the complaint that would justify that?
Well, and in fact, that was really the only issue that the lower court discussed, because at the motion to dismiss level, I did raise that there was enough for qualified immunity purposes on both reasonable suspicion and a lack of information that this was converted to an arrest by the minimal use of force that applied here. The plaintiff did not argue at all that there was an absence of reasonable suspicion. Because the plaintiff didn't argue it at all, the trial court didn't make any decision based on an absence of reasonable suspicion in the complaint. The trial court's sole focus was whether or not the use of force that was employed by Officer Grossman converted the Terry stop into a Fourth Amendment arrest without probable cause. And for that, I mean, I go strictly to Washington versus Lambert, that tells us that intrusive means can be used in a Terry stop. And the quote is, where the suspect is uncooperative or takes action at the scene that raises a reasonable possibility of danger or flight. A reasonable possibility of danger or flight.
What facts support that proposition here?
As Officer Grossman is questioning CL, trying to determine what happened, he turns to leave. Officer Grossman grabs him.
Turns to leave. Yeah. Now, what there suggests danger to the officer?
Well,
nothing.
Danger is only one of the four prongs in Washington versus Lambert.
I'm just checking off the ones that really don't survive anymore. You're potentially talking about flight, but turns to leave sounds to me like well short of trying to get away. I mean, as far as the boy is concerned, he thought he answered the officer's question. He's not aware that he's in custody. He turns to leave, and suddenly he's grabbed. What facts, as alleged in the complaint, justified the application of force?
During the middle of an investigative stop, if a person turns to leave, force can be used to keep them there. If they escalate that force by screaming and trying to move away further, then that can also apply. Where do I get that from? The Ninth Circuit decision in Bennett versus Gow, which talks exactly about that. Although the crime was minor, Bennett turned the encounter from bad to worse by refusing Officer Gow's instructions to hand him the license and by walking away, despite the officer's instruction to stop. He was taken to the ground, and the Ninth Circuit Court of Appeals in 2009 determined that that was not excessive force and that was proper police action. That would inform somebody like Officer Grossman in 2017 that he can use some amount of force to keep the person there during a Terry stop, and if they escalate it, they can be taken to the ground. And Officer Grossman, as alleged in this case, isn't using profanity, he isn't using guns, he isn't using tasers, and even when they're on the ground, according to the allegations themselves, he's still trying to figure out what's going on. There's no clearly...
What the allegation says is he turned to leave, the officer grabbed his right wrist, began bending his arm behind him, telling him don't go anywhere, grabbed his arms, forced them behind him, and began to handcuff him. That's what the complaint says, based only on his turning to leave.
And Bennett versus Gauss says that is a lawful action to employ force at that point. And in fact, there is no clearly established law that I can find from CL, from the trial judge in the original opinion, and even the supplementary authorities that would indicate that Officer Grossman was required constitutionally to do otherwise. And if he was required constitutionally to do otherwise, this is how criminal suspects who are encountered in a Terry stop can just avoid detection. Turn to leave because that's okay. I don't know any law that countenances that as a reasonable response by the suspect. And I see I'm over time and probably into my rebuttal.
It's okay.
Thank you.
We asked you a lot of questions. We'll give you a minute in rebuttal, okay?
Thank you, sir.
Mr. Scott?
Good morning, Your Honors. May it please the court, Tim Scott for the minor CL, the appellee in this case. I'd like to just start by directly addressing some of the questions that the court was putting to opposing counsel regarding the allegations in the complaint. Because as the court pointed out, this motion was brought at the pleading stage, and the pleadings, of course, comprise the universe of facts that should guide this analysis. Contrary to either the arguments or the suggestion by the appellant in this case, the complaint certainly didn't plead or allege some sort of a good faith belief based on objective facts that CL was in fact under the influence of drugs or was otherwise committing a crime. The specific answer to the court's question as to what were the objective facts that were pled comes primarily to the extent that the defendant relies on them from paragraph 22 of the complaint, which describes stimming objectively. And this is at ER page 86. Stimming or self-stimulatory behavior is the repetition of physical movements and sounds or the repetitive movement of objects common in individuals with developmental disabilities. And then there's a cite to the CDC, and it says that people with an ASD or autism spectrum disorder might spend a lot of time repeatedly flapping their arms or rocking from side to side. So what we can take from that in terms of what the officer was observing was at best some repetitive physical movements, which I respectfully submit to the court ought not seem out of place for children in a park in broad daylight, as the court pointed out.
Counsel for appellant says that below you did not argue to the district court that there was no basis for a Terry stop. Is that right?
No, I disagree with that. The complaint at paragraph 42 specifically says that there was no probable cause nor reasonable suspicion.
No, I understand the complaint says that, but what your colleague says is that you basically were arguing only that there wasn't enough that the force wasn't appropriate because there wasn't probable cause for an arrest, but that you never argued that in responding to the motion that there wasn't enough reasonable suspicion to justify a Terry stop. Is your colleague correct?
I certainly didn't concede that there wasn't reasonable suspicion. If we didn't explicitly argue it, and I would be surprised if we did not, but if we didn't, then what I would suggest to the court is that we can still here on appeal look to the totality of the record and determine whether the actions stated a constitutional violation or not. So I don't know. If we didn't, I don't think that should be dispositive here on appeal. The inquiry could still be whether there was probable cause or even failing that, whether there was reasonable suspicion. I would suggest that there is an argument to be made that it would be difficult at the pleading stage to go and find what has been pled as a full-blown arrest was merely a Terry stop. First, I don't think there's facts in the record to make that determination. But also, I would argue that unlike a criminal case, where of course courts do make these judgments as a matter of law in a suppression context, in a civil rights context, there's actually a model civil jury instruction. I think it's 9 point.
But what counsel for the appellant is arguing is you basically conceded that there was enough for a Terry stop below, and that when the boy turned to leave, and if there was enough for a Terry stop, that justified some force, and then after that, the force all followed reasonably because the force was justified for a Terry stop, which counsel for the appellant says you conceded below.
Well, we certainly didn't concede it. We certainly never acknowledged or affirmatively said, yes, there was reasonable suspicion. That's absolutely untrue. We never said anything to the contrary. So at a minimum, we should look de novo today if there is reasonable suspicion, and the facts don't provide that. The facts, as I was saying, state simply that there was this repetitive movement. It's also important, I think, to point out that to the extent the complaint discusses Officer Grossman's belief about drug use, the complaint always uses the language claims that he mistook it for drug use, or says that he mistook this behavior for drug use. And to the extent there's allegations about being a drug recognition expert, that's also sort of pled with a pinch of salt, if you will, in that it says the department claims that he's a drug recognition expert despite X, Y, and Z training, or despite not maintaining records for such and such. So it certainly isn't alleging or confirming that he's a drug recognition expert by any stretch. I would also argue to the court that even if we were to assume, and we don't, we push back strongly against the idea that there was reasonable suspicion, but even if we were to assume that for the initial approach that there was reasonable suspicion, the law has been clear for many, many years that reasonable suspicion or probable cause can dissipate when the officer learns new facts that contradict whatever the suspicion was. I think a helpful case in that regard is the Seeley case. In that case, the alleged crime was much, much more serious. There was allegations that two males possessed a firearm, and interestingly, when the officers arrived at the scene, they actually saw teenagers with what appeared to be a firearm, which would at least initially tend to confirm and corroborate those allegations. But upon further inquiry, the officers were able to ascertain that no, this was simply a toy gun. And at that point, this court held, and this was a civil rights case too, not a criminal case, that any cause there had dissipated, and then to continue the detention was a violation of clearly established law. Now, if that's the law, when we're dealing with potentially a gun being out in public and actually seeing something that looks like a gun, to compare that here, where the alleged crime is perhaps using some sort of a drug or something, and when it's conclusively shown that that's a string, not once but twice, the argument is that certainly at that point, any suspicion has to dissipate. So that goes to
Mr. Scott, hold on 1 second. We may be losing audio. Could you pause the timer real quick? Could you give me a test, Mr. Scott?
Yes, Your Honor. Yes. I have this backup technology.
It says it's still active.
Kwame, if you could sit there just for a second. Mr. Scott, go ahead and continue your argument. Your voice is always very easy to hear. I just want to make sure for the YouTube. Can you tap your microphone? Yeah, see, it's not.
What? I bet, there we go.
Oh, no.
You were leaning right over the bush.
So Mr. Scott muted himself.
I did. It was my own fault, per the norm.
Fair enough, but now I believe it is operating. I think we're good, Kwame. If you could start the, thank you.
Very good, Your Honor. My apologies for muting myself. The probable cause or the unlawful seizure isn't the only claim that we pled. We also pled excessive force, and those operate independently. Even if this court were to find that there was a reasonable suspicion, which we dispute, and that there was probable cause, which we dispute, there's still plenty of facts that are pled to show that the actions that were taken thereafter are excessive under this court's law. The Graham analysis is fairly straightforward. There is no allegations of an immediate threat of violence, of risk to anybody. The severity of the crime is very modest. There are no allegations of active resistance or flight. And that maybe bears just a quick comment that much of the defendant's analysis turns on allegations of quote unquote fleeing or active resistance. Neither of those can be fairly inferred at the pleading stage. Now, granted, we did state that CL turned to leave, but that was pled to highlight that he was seeking to end the encounter, which is absolutely his rights as a citizen, and that there was a seizure that took place, not that he was fleeing. We certainly never used that word, and that was not the intention that it was offered under.
Mr. Scott, if I could ask you about a case that opposing counsel cited, Bennett versus Gow.
Yes, sir.
As I understand Bennett, in that case, the Ninth Circuit found that Mr. Bennett had actually committed a crime.
That's right.
And in response to the crime, the question was the officer's actions in response to the crime proportionate or not?
That's the distinguishing factor, is that it cites Washington Revised Code, I believe it was, and that there was probable cause that Mr. Bennett had stolen an identification and kept property that didn't belong to him. That is a crime, of course, and then once there is probable cause that a crime was committed, then of course an officer can affect some proportional and reasonable amount of force to effect that arrest. That kind of begs the question in our case, because certainly we don't plead nor concede that there was probable cause that any crime had been committed. And for what it's worth, that is also an unpublished case with a very, very modest statement of facts, and I would submit that that doesn't really give carte blanche to officers to act in that manner.
But even with the facts that are in the case, it seems to me very different to say, well, the plaintiff committed a crime. Now the question is, was the officer's response proportionate compared to this case where, according to the complaint, the plaintiff did not commit a crime.
Right.
He was just doing this, basically.
He was playing with a piece of string, and those are the allegations and that does distinguish it to the extent that, again, the defendant would like to characterize this as resisting arrest. Again, that's reading too much into the complaint. We did plead to sort of demonstrate damages or to demonstrate the extent of the excessive force that CL did scream when his arms were being twisted behind his back and that he sought to move away. That's different, and the inference should not be, at least at the pleading stage, that evinces resisting, but rather the inference should be that was the predictable consequence of an excessive application of force. Ultimately, Your Honor, I would conclude with this. At ER 686, we made the allegation that CL, in his entire life, including times when he was left alone for brief moments of time in the park, has never once, by anyone, been mistaken for somebody that was under the influence of drugs or that was committing some sort of a crime. That pleading, I think, is relevant because the inquiry here is whether all reasonable people would agree, all reasonable officers would agree that there was not reasonable suspicion or probable cause under these circumstances. So based on these pled allegations, we actually have a sample size of everyone who has ever seen CL playing in the park. Literally no one except for the defendant, Officer Grossman, has ever made the judgment that he was committing some sort of a crime. The proposition that we're pressing here, I think and hope, is relatively modest, which is when an adolescent boy who is visibly developmentally disabled is playing with a string in a park, we ought not go around forcibly seizing him, slamming him against a tree, slamming him to the ground, and continuing to press weight against him even as his hand turns white and even as his caregiver is explaining explicitly that the boy is autistic. I don't think that is overly controversial or would hamstring a reasonable officer, and I think that certainly at the pleading stage that is enough to state a claim here. And unless there's other questions, I would submit on that, Your Honors.
All right, thank you, counsel.
Thank you so much.
We'll give him 1 minute.
Thank you, Your Honor. Judge Owens, as you indicated in the SB versus County of San Diego case, qualified immunity has been quite an evolution from the Supreme Court and to the Ninth Circuit. When you said, we hear you loud and clear about what we need to do, you were saying what we need to do is make sure that there's clearly established law, particular law that would put this particular person on notice that what they're doing is unconstitutional, that every reasonable officer would know it. Now, all the things about reasonable suspicion you will find at ER 86 and 87 in paragraphs 21 through 26. What this court will need to do is tell us what the clearly established law is, that a person with that type of training can't reasonably suspect drug use, because we didn't provide it, counsel for appellee didn't provide it, because the issue wasn't briefed. So as a threshold matter, that's something that if this court is going to go there, it's going to need to do itself. There's no clearly established law that prevents an officer from doing what Officer Grossman did.
Thank you very much, counsel. Thank you both for your argument in this case. This matter is submitted.